Welcome everyone, and thank you for joining us at this, the second webinar in this year's AFSA series entitled The Cutting Edge, in which we discuss arbitration in the modern world. We've all of us sat in arbitrations and marveled at the quantity of paper and the number of files which clutter the proceedings. And we've also marveled at the fact that at the end of the day, barely 10% of all that paper turns out to be of any value in deciding the merits of the matter. This afternoon, AFSA is delighted to host a webinar presented by one of our founding members, Pinsent Masons, which addresses problems of this sort in the light of the realities of sustainability targets and environmental concerns. Pinsent Masons, as I think you will all know, is an international law firm employing more than 2,500 staff in the United Kingdom and across the globe. And joining us this afternoon from Pinsent Masons are Thomas King and Chloe Diaco, who are senior associates in the Johannesburg office, and Pamela MacDonald, a partner situated in Qatar. Welcome all of you, and without further ado, I will ask Thomas to take over this webinar. Thank you.
Thank you very much, Michael, and good afternoon, everybody, and thank you for taking the time out to join us today. As Michael said, this is a session around arbitration in a modern world. But what do I mean by that? Well, what we'll cover today is why we as practitioners, institutions, arbitrators, clients, and experts should conduct arbitration in a more environmentally friendly and sustainable way, and how that can be done without reducing the efficiency of arbitrations, and in fact, how sustainable practices will in fact improve them. And why does that all matter, you might ask? Well, the 2021 ND Gain Index currently ranks South Africa 92nd out of 181 countries globally, recognizing the country as vulnerable to climate change impacts. Also, with the country's heavy reliance on fossil fuels looking set to continue for the rest of the decade, the greenhouse gases per capita index is very low and well below the minus 1.5 degrees C COP26 target for 2030. So change is needed in South Africa if those targets are to be achievable. And that change is needed across industry. And certainly the direction of travel in the international arbitration community is towards the recommended adoption of sustainable practices. We as professionals and as an industry must therefore be prepared to be increasingly challenged on whether our business practices are sustainable and whether things could and should be done differently. So to set the scene for today's seminar, I'm going to start with a confession. Last year, I led 9 large-scale DAB and arbitrations. Every single one of them involved 3 panel members, multiple witnesses of fact and experts, counsel teams, extensive bundles and hearings ranging from 1 to 14 days. In each of those proceedings, we printed all of the bundles, sometimes running into over 50 lever arch files for each of the tribunal members, our counsel team, and witnesses. On average, that's around 6 to 7 copies for each matter, running into many thousands of pages. And what's more, in producing those bundles, teams of candidate attorneys, paralegals, and interns would often work through the night to get those bundles produced and shipped to where they needed to be. Now, whilst the reason those bundles were produced in hard copy was because they were requested in hard copy, I'm nevertheless flabbergasted by that wastage. And by wastage, I don't just mean the obvious physical wastage. After all, Once the matter is done, the hard copies become completely obsolete and only partially recyclable, but also wastage in terms of time and experience. How much better utilized would our candidate attorneys have been, for example, if the time they spent printing bundles was used to carry out further research or develop points of evidence? But what makes this tale particularly poignant is that I bet every one of us on this webinar today has done something similar over the course of the last year. And just think about the scale of that for a minute. Now, thankfully, I'm joined today by two of my colleagues, Pamela MacDonald and Chloe de Jager, who will explain how arbitration can be conducted in a more sustainable way and why we should all make efforts to do so. Pamela is a partner in our Qatar office with over 11 years disputes experience in infrastructure and energy projects. And she and I used to be colleagues in our London office many moons ago, although she now advises clients on complex engineering projects in the Middle East. Pamela's ranked in Chambers and Partners and described as a rising star who is widely recognized for her skills in ICC construction arbitrations. Chloe is a senior associate and colleague of mine in Johannesburg and has an MSc in construction law and dispute resolution from King's College London, and advises clients in the energy, construction and mining industries, focusing also on dispute resolution. Now, before I introduce our first speaker, there is a Q&A function on your screen, and please do feel free to use that to log your questions as we go through today's session, and we'll pick up those points at the end and hopefully get through them all if there's time to do so. Now, Pamela, if I may, I'll come to you first. How could my DABs and arbitrations have been conducted more sustainably?
Well, what a question. Thank you very much indeed, Tom, for having me on, and to AFSA for hosting this really important webinar in terms of its topic. I too have memories like you, Tom, and my first case that I ever did, to hark back when I was a trainee, it was a 240 lever arch file hearing bundle, 3-member tribunal at the IDRC in London, and I was responsible for getting a truck to take the hearing bundle to and from the IDRC every day for 2 weeks. It was awful, but things have changed, and what I'm going to talk about now is the campaign for greener arbitration. So the campaign for greener arbitration, it was founded by an arbitrator called Lucy Greenwood in 2019. And Lucy had the goal of reducing the carbon footprint of international arbitrations. And so she formed a steering committee, and it had stakeholders from all different parts of the global arbitration community. I'm a member of that committee, and then the campaign set about producing a sort of guiding principle, like its North Star, which outlined, the suggested commitments and actions, and that's in the form of the pledge that you can see on the slide there. That's quite a broad description of the measures that arbitration practitioners can consider. And then the steering committee decided that what was needed was a set of tangible action items and clear instructions to help people reduce the environmental impact of their arbitration practices even further, and so that they wanted to give, we wanted to give people practical advice and steps that they could implement to accomplish the campaign's pledge. And so on the next slide, you'll see the campaign's green protocols, and that's what we produced after the pledge. So these protocols are a product of an incredible amount of thinking from some of the most brightest minds in the legal industry, lawyers, members of arbitral institutions, people from hearing centres, of course, arbitral tribunal members as well. They came together in a working group and produced this set of green protocols, and it's a concise sort of set of directives that are intended to guide us in an effort to reduce the environmental impact of arbitration practice. And it's worth a read, even if after this webinar you decide this isn't for you, because it's actually really interesting to see the product of all of these great legal minds coming together, especially for me, the model procedural order, the model green procedural order. It's a really good read, but you have to read them anyway, the one that's relevant to your practice area, to properly understand what I'm explaining to you. And in particular, when you're reading them, look at the first sort of words of each sentence that's been deliberately chosen, because those words, they're non-prescriptive, and they're used to make sure that parties that do decide to adopt these protocols or the model green procedural order in your arbitration, it's not going to cause you to somehow be in breach if you don't fully comply with it every time. The message is that you are encouraged to consider, you know, where it is appropriate, we will endeavour to, etc., etc. So it's not prescriptive. It's intended to be there at your back as your you know, support when you want to confidently suggest that things should be done differently. In terms of our own Pinsent Masons firm involvement, we've signed the pledge, and we formed a climate change and international arbitration team. We reviewed each of these the protocols that were relevant to us to sort of test the extent to which we thought compliance was reasonable, and in the end that culminated in us wholeheartedly adopting the protocols. And it was a really easy decision, to be honest, because of the thought that had gone into the drafting of these protocols. When you read them, you'll see for yourself what I'm saying, and they're things that you'll read and you'll think, yeah, we should be doing that anyway. This is the sort of modern arbitration practice that we should expect of ourselves. So I would strongly encourage you to read the protocols. Next slide. There's a lot of really valuable stuff in those protocols, and I really can't do it justice in the little time that we have today. So please do read them if you haven't already. And hopefully you'll be inspired to adopt some of their recommendations. And just to pick up on some of the key recommendations, though, for those that don't want to go away and read them for themselves, that the themes are things like electronic communication, so using email to communicate rather than hard copy letters. You know, where there's large data like exhibits, you know, using cloud-based technology platforms to share the documents, unless of course your arbitral rules or the contract says otherwise. You know, we completely understand that the parties or the rules might prescribe something different, but it's just moving away from the concept of hard copy bundles by default, basically. And in particular, in relation to electronic document production, so that's something we mostly do by default anyway in modern times. We rarely see hard copy disclosure review, but electronic document production is, you know, strongly suggested as being the best approach. And that's helpful because our clients' documents tend to be electronic anyway, but there are instances, I've seen it and I still see it, of practice where you've identified what the documents that you want to disclose are out of the millions, and often partners, frankly, instruct that those disclosable documents should be printed and we should read them before they go off. And I've seen that happen, and we should challenge ourselves on that kind of practice, because that is unnecessary. If it's electronic disclosure, it's not carbon efficient. So it's about having that protocol in place. You know, it enables perhaps more junior members of the team or other members of the team to challenge that behavior and those decisions when it comes to e-disclosure. And then the other kind of side of this as a theme is travel. So in terms of meetings with witnesses and experts, consider using VC by default. Cut out the travel, especially air travel, which is by far the worst greenhouse gas emitter. And similarly, you know, conferences, procedural, substantive hearings, we should at least be considering conducting them remotely via VC. Now that point there, you know, should we be virtual by default when it comes to hearings, that I fully accept. That's that's probably the most controversial point out of all of the campaign's kind of mantras. It causes the most amount of debate among lawyers and tribunals, and especially barristers, in fact, who often conduct the advocacy. Personally, I'm firmly of the view that virtual hearings are better, not only because of the carbon-related reasons, but also cost reasons for our clients. Hearings are, you know, the most expensive phase on disbursements if they are in person, and also because, you know, anyone who's done a virtual hearing by now will know that when a witness is sitting in front of a laptop or a screen with a webcam, you have a magnified, as you have with me now, a magnified impression of their face, which you don't actually get in person. So you can really tell their integrity sometimes when they're, sitting so visibly in front of a camera. So for me, there's many reasons why, but it is, I fully accept it's something debated. And if all of the parties in the tribunal are in country, I also fully accept that you would want that hearing to be, in person, because no travel's needed. But if everyone's traveling from all over the world, then that is a considerable cost to our environment to fly everyone in for the sake of the hearing, when it could be done by VC. And then where travel is necessary, or printing is demanded by the rules or the tribunal or whatever, then the other theme is, consider how you can offset those residual emissions by using approved corporate offsetting standards, and those are available on the internet. So those are some themes. I wanted to also just touch on the next slide on how how we at Pinsent Masons have implemented some of this, just to sort of ground it in reality for a minute. So as a firm, we recognise that operating 26 offices in a global network, and I'm afraid I'll have to correct Michael, it's actually 3,500 people, not 2,500 at Pinsent Masons. A lot of people. And we recognise that has a significant environmental implication, and we want to implement real, tangible changes that have a positive impact. So we found it, as I say, very easy to sign the pledge. That was an easy decision. And we now have formed this IA climate change team, and that sort of complements and progresses our firm's wider climate change ambitions, which are to halve our carbon emissions by 2030 as compared to 2019 levels, and be net zero by 2050. And in terms of the practicalities of that, first we formed the team. We reviewed carefully the 6 protocols released by the campaign. We immediately identified this wasn't just something that the lawyers were going to be able to give their blessing on. It involved firm-wide facility management input, and it touched on areas that we were already considering as part of our climate change and sustainability initiative to be net zero, like lots of firms already are. And so we did some investigatory work. We spent time looking at the less obvious points in the green protocol for law firms, and that was quite fun, actually, very educational for me personally. So I learned things like the type of printer, toner and ink that we use, and I learned where we source our paper from, checking that it's elemental chlorine free, which means that it's bleached using chlorine dioxide instead of environmentally less acceptable chlorine gas. We investigated the type of printers that we're using. We made sure that we're using LED UV capable printers rather than mercury containing fluorescent bulbs. So this sort of thing, as I say, that you wouldn't naturally know, but actually these investigations are capable of being done, and small changes can make the big difference. And then at a sort of wider level, we're adopting smart building optimization technology in 2 of our largest offices in our network, which provides live carbon intelligence information from the sensors in the building to analyse and optimise our energy performance. And we've also agreed a corporate power purchase agreement so that electricity purchased for our UK and Irish offices are from renewable sources. So as a firm, we're doing an incredible amount anyway to drive down our carbon emissions, and that all plays into the easy decision that it was to adopt the campaign's protocols. So just going back to the steps that we took, we then had discussions around the technology that was available to our arbitration practitioners and what was more widely available in the market to make the adoption of electronic and virtual more easy. And we quickly again formed the conclusion that there was absolutely sufficient technology freely available, and we already used it, in fact, on a lot of our cases, things like Kofax for e-bundling and Exhibit Manager, and of course MS Teams and the Zoom platform that we're on today. We were already engaged in all of that stuff. So it was more a question of how to transition everyone onto those platforms by default, rather than adopting the traditional hard copy written post-it note approach to marking up bundles. On the next slide, you'll see reference to 2 particular protocols. So there's the Model Green Procedural Order and the Protocol for Arbitral Proceedings. That second one, the one for arbitral proceedings, that's particularly useful, a set of sort of guidance on measures that you can take to minimise the impact of your actual arbitration proceedings on the environment. And it goes hand in hand with the Model Green Procedural Order, which has got the kind of suggestions to be included in a procedural order at the start of your arbitration. So just to break those two down a bit, the proceedings protocol, that's about things like the parties' submissions, documentary evidence, conducting hearings, travel, and it's also got some helpful points about offsetting carbon emissions. And then the model green procedural order, that's more to do with communications, the conduct of proceedings in terms of technology, platforms, software that can be used to annotate documents and so on, so that both parties are kind of using the same thing. It's a really fascinating read. I would strongly encourage everyone to at least read those two if you are actually counsel representing parties on an arbitration, or in fact an arbitrator. And the important thing to say is the specific ideas included in these protocols, they won't surprise you. They're things you know you ought to be doing anyway to create a workspace that's got a reduced environmental footprint anyway. And the formal adoption of the protocols, that's just sort of gives you confidence in challenging behaviour. It's including from tribunals actually and opposing parties. The kind of behaviour that we know now is unnecessary. It's clearly just being done because that's how it's always been done, but there is a better, more carbon efficient way. And together, the key points for me from this are, written submissions and evidence should be served electronically, use a secure link sort of platform, cloud-based platform or whatever, and hearings should be, I think, conducted remotely unless the parties are all in country. We're now at a point in time where we have tried and tested the technology, and it's fair to say it works perfectly well. Provided the participants have strong internet connection and that everyone exercises patience in moments where there is a delay, because those things do happen. So on my last slide, and I'll stop talking and hand over, I just want to talk about kind of cultural tilt. Naturally, this movement involves humans adapting to what are well-ingrained working practices, and it's something that requires cultural shift and importantly, the feeling of genuinely wanting to improve your carbon footprint. And helpfully, what I found is that isn't something you really need to convince people of. That's a movement that we are, living through anyway as humans. And just to ground that, at Pinsent Masons, we are one of the 22 founding members of something called the Net Zero Lawyers Alliance, and our ambition to reduce operational emissions, as I said, half by 2030. That's something that the firm wholeheartedly got behind. So when it came to making this suggestion around the adoption of the protocols in our arbitration practice, we were already kind of desensitized to the concept that there's change coming, and this was a very organic decision for us. But there is, of course, a hard copy mentality for some practitioners, and to some extent COVID's driven change in that respect, which has been great. But to push that along further and to make sure we don't just revert the delivery of practical advice to practitioners of the software that's been available on their laptops this whole time, for example, to use electronic sticky notes on Adobe PDF, for example, as well as having in-house e-data managers as we do at Pinsent Masons. That all helps with the transition. And something that I think we feel emotionally most affected by in all of this is the desire for in-person meetings. We were talking about this just before we came online, and I completely get that, the feeling of a need for human interaction, and sometimes thinking that's more effective. But the fact is, you do still have those moments of human interaction in the office. Now things are returning to normal, perhaps not as regularly as it once was, but the absence of those in-person interactions is replaced, I think, by the massive benefit of having the opportunity to collaborate on your arbitration cases with practitioners in other countries, in other offices within your network, and the cognitive diversity that introduces to the team, which is hugely beneficial for you and for the case. I would argue that might lead to you being more successful in the case if you've got massive cognitive diversity, which you can do when you have a virtual kind of approach to the arbitration. I'll mention also, because I've put it on the slide, it's clear that the arbitral institutions and that they're behind the movement, that resistance will be difficult to maintain in circumstances where the 2021 version of the ICC rules permits tribunals to decide that a hearing will be conducted remotely, and also, I haven't put it on the slide, but IBA rules, the revision to them just in December 2020, Article 8.2, that encourages tribunals to consider time cost and environmental concerns guidance when determining whether a hearing should be held remotely. So, and the IBA rules and the ICC rules, I think we can all agree that those are important arbitral bodies, and we do gravitate towards them for sort of what's the modern way. There's clear guidance given there as to the direction of travel or non-travel in this case, but by and large, the speed at which practitioners generally are adapting to the change is very encouraging, because of course international arbitration can be incredibly carbon intensive. As Tom said at the start, there's massive bundles being printed and all of the travel that goes with it, but equally it does lend itself to virtual technology. And if there is still any naysayers, then the thing that you really can't ignore, I think, is the cost impact that this alternative approach has. It's clearly very compelling indeed for clients. And interestingly as well, I'll just mention as my last point, it's interesting to funders. And if third-party funding is something that you think might take off, which I think most arbitration practitioners do think that now, then I think they've really got the potential to propel this movement forward, because it's in their interest to keep a lid on the costs of arbitration proceedings, and that's what this all does. So I will stop there. I've probably gone over my time limit already, but I'll pass back to you, Tom. Thank you very much.
Thank you, Pamela. There's some really interesting ideas there, some passionate ideas. And importantly, I think, as you say, they're not necessarily groundbreaking. These are things which we're doing already, or we're doing some of already and can do more of. For example, we're all by now well used to Teams, Zoom, Google Meet, whatever the case may be. So the mentality shift required to drive greener arbitrations ought not to be necessarily a seismic one. Chloe and I will now develop a little of what you've said, Pamela, and we'll focus a bit more on the practical aspects of remote hearings, electronic document management, and how they can be used to all parties' advantage during arbitrations, and in so doing, importantly, tick that all-important environmental and green box. So what is a remote hearing? I mean, hearings have been undertaken remotely, i.e. away from physical attendance at court or arbitral institutions for many years. The civil procedure rules in the UK, for example, provided for hearings to be conducted by telephone in a number of prescribed circumstances, and even held for video conferencing in certain circumstances. The practice direction provided that they were to be the default, where you had interim applications, case management conferences, and pre-trial reviews, which lasted no more than an hour. So there were some exceptions, but the general rule was that attendances ought to be done in that way, unless there was a good reason to take a contrary approach. And in South Africa, the uniform rules of court, whilst not necessarily so express, or at least not so pre-pandemic, did permit the court to make any order as to the conduct of the trial, see Rule 39. But in the last few days, I, like probably many of you, have seen the Deputy Judge President's notice, which confirms that the status quo in Gauteng, at least, would continue for the second term of 2022, and that status quo being that remote hearings are to be the default position. Of course, it's commonplace as well to use video conferencing prior to the pandemic, where witnesses were based in other jurisdictions and could not attend in person. So the concept of a remote hearing isn't a new one. However, following the pandemic and now as envisaged by the campaign for greener arbitrations, we're now, as a profession, industry, coming to understand remote hearings in a different way. Now, when we talk about a remote hearing, we tend to think of a hearing conducted almost entirely by telephone or video conference, and a substantive hearing running into many days or weeks. In other words, all the parties, tribunal members, witnesses, experts, transcribers, are all located in different places geographically. A hybrid hearing, by contrast, is one where some participants are present in a physical courtroom or tribunal location, while others attend remotely, usually by video link. So in practice, a hybrid hearing might often involve the advocates and sometimes attorneys attending physically before a tribunal, while others, including witnesses, attend remotely. And there's even variance on that theme. And a common practice in the DABs and arbitrations that I've run over the last 2 years involve purely remote attendance on the tribunal, but the physical gathering of your team in one place as a sort of hybrid plus type model. And certainly insofar as arbitration is concerned, I would expect the majority of practitioners on this call to have adopted a similar approach. I'm sure that we would all have been involved in a remote hearing of some nature, whether a substantive hearing or an interlocutory one prior to the pandemic. But now I would be very surprised if the experience of most people on this call is that the majority of hearings, at least in arbitration, are undertaken on at least a collective mindset has shifted massively from remote hearings being the exception to now being the norm. So when we talk about doing things sustainably and conducting arbitrations in a greener way, at least insofar as remote hearings are concerned, we're a long way down that track already. Now, the two most document-heavy processes in any arbitration are discovery or disclosure in other common law parlance and hearing bundles. And over the next two slides, I'll look at those two processes and how they can be made leaner and greener and more efficient. Now, looking at discovery first, most arbitral rules provide for the disclosure of documents in some form. And in South Africa, at least, the powers of the court to order discovery for use in arbitration are also preserved by the Arbitration Act. Most commonly, rules will call for a party to append documents on which it relies to its pleadings or its witness statements and expert reports. But of course, what we're most interested in is, as practitioners, in what the other side are not showing to us. And again, most rules allow for a party to make application for disclosure of documents which they believe may be in the possession of the other party and which may be beneficial to their case or adverse to the opponent's case. But the point for present purposes is that those applications and the resulting disclosure can be vast. In any arbitration, it's therefore crucial to have party and tribunal management and ownership of this process from the outset, and it ought to be an item on every pre-arbitration agenda. And that's because discovery is not confined to just hard copies. As Pam alluded to earlier, in fact, in today's modern businesses, the vast majority of documents in a party's possession are in soft copy, so-called ESI, electronically stored information, which we find everywhere on laptops, databases, servers, mobile phones, and even social media accounts. So part of the discussion at pre-arbitration stage should therefore revolve around the use of technology in order to ensure that document management activities are undertaken efficiently, proportionately, cost-effectively, and climate-friendly. There are now many providers of e-data services who are experienced in managing document review exercises of all sizes and scales, and can do so wherever the parties are located in the world. An e-data provider can be employed to collect ESI forensically. Now, not only can that help to streamline the process of collecting ESI, but it also helps to preserve it, thus ensuring the integrity of the process. An e-data provider can also help to reduce the volume of documents for review, because once collected, that ESI can be searched and filtered by use of keywords, date ranges, custodians, etc. That also reduces duplicate data. And once filtered, the relevant documents can be loaded onto a web-enabled review system along with any hard copies which have been scanned. Yeah, that's right. Remember that hard copies can be scanned in and OCR to enable them to be searched in the same way as existing soft copies. As Pamela referred to earlier, why should the default position be to print everything into multiple files, review those by way of an army of paralegals in a war room? Do it the other way around. This will mean that all documents, even if in hard copy originally, are on the same electronic platform and able to be searched, filtered, and reviewed in the same way. And once a consolidated electronic database is ready, the legal team can then effectively review and categorize and analyze those documents. And even here, technology can help, for example, by using predictive coding based on decision-making of lawyers. And that can massively reduce time and cost if that's deployed effectively as well. But more importantly, if you've engaged with the other side and the tribunal early on, the other side will be doing the same thing. And that means that electronic copies of disclosure can be provided in an agreed format or even on the same platform. Now, leaving aside the obvious time and efficiency savings that that approach can bring, it's also a green and sustainable approach, which avoids large-scale hard copy data dumps and removes significant wastage. Now, turning to bundling, you'll all hopefully remember my confession at the start of this session. Bundling can obviously be an extremely labor-intensive and document-heavy process, particularly in large-scale, complex arbitrations. And you can just ask your paralegals, candidate attorneys, and facilities staff who will back that up. Certainly ours will here. It's very common, certainly in disputes which I've been involved in, for bundles to comprise hard copy files and also soft copy data, most commonly spreadsheets and other linked documents. So generally, we're having to use soft copies anyway, even where there are hard copy files being used. So why can't the entire bundle be managed as a soft copy? Well, it can. And in fact, in my experience, it generally is. The issue is that the bundle is printed as well. That's like watching your favorite Netflix series and then buying the DVD. Now, why would we do that? Well, there are good reasons why bundles are printed in hard copy. First, we like it. We like the feel of the paper, the knowledge that we can just pick it up and put it down. We like to be able to make notes in our favorite red pen and highlighters. And then we can put physical sticky notes on the top corners of the pages to make them easier to find. That's probably very easy to see where I'm going with all of that, and I don't mean to be facetious, but all of that can be done in an entirely soft copy way, and in most cases much more easily and efficiently. The availability of Kofax and other PDF software, for example, allows note-taking, bookmarking, and all manner of other review tools to make your life easier. Now, the reality is that most people would agree with that sentiment, I think. However, personal preference for hard copies generally prevails, and it can be hard to shift that mentality. And I'm not here to tell everyone to change the habit of a lifetime. I mean, sometimes I like hard copy documents too. I mean, all of my contracts, for example, are printed in A5 booklets, and I like to navigate them in that way. But what's important is that the parties in the tribunal engage, again at that pre-arbitration stage, in relation to the preparation of bundles. Generally, it's for the claimant to prepare bundles, but the reality is that a good bundle is one which is prepared according to agreed principles and in a collaborative fashion. So, for example, the parties should discuss and agree not who prepares the bundle, but how it should be prepared. And the question should be asked, should that bundle be in hard copy or electronic copy? If electronic, what are the rules? The Courts and Judiciary Tribunal in the UK, for example, provide that e-bundles should be provided in PDF format. Each entry in the index should be hyperlinked to that document. All significant documents should be bookmarked and all pages must be OCR'd. Points such as those should be agreed up front, or at least a direction for a bundle protocol to be produced and agreed within a certain time. And finally, consideration should be given as to how the bundle is presented at the hearing. If an e-bundle has been prepared and there has been proper engagement between the parties, there's no reason why that bundle cannot be administered electronically at the hearing too, either by the parties' representatives or an e-bundle provider. And importantly, at least by giving consideration to those issues, we're taking a step in the direction of making our arbitrations greener. Perhaps a full-scale e-bundle is not used in your next trial, but at least have the discussion about it. Maybe an electronic core bundle of documents is used and you see how that goes. Or perhaps the main bundle is electronic, but only the core documents are printed. Whatever the approach, you're thinking about it, which raises awareness, and in time, habits and perceptions will shift. And I'll just hand over to Chloe.
Thanks very much, Tom, and thank you to AFSA. So Tom's been through some of the ways in which arbitrations can be made more electronic and greener. But what we thought we'd do is we'd look at the various arbitral rules about remote and what they say about remote hearings and e-data and bundles. Pamela obviously has touched on already some of the international examples, one being Article 26.1 of the ICC, the 2021 ICC arbitration rules, and the other is that of Article 8.2 of the IBA rules on the taking of evidence in international arbitration. But moving to AFSA, more importantly for these purposes, so what do the AFSA international rules of June 2021 say? And what do they say about remote hearings and electronic documentation? And how can they help facilitate greener arbitration practices? Well, thankfully, the AFSA international rules are forward-thinking and promote the sustainable conduct of arbitrations. Well, how do they do this? Firstly, the request and answer may be submitted in electronic form. And in fact, Article 5.1 of the rules expressly provides that electronic means of delivery or transmission are preferred. This ought to encourage the parties and the tribunal members to manage their submissions in electronic form, right from the get-go. This is also important as it clearly encourages digitization from an early point in the proceedings. In common with all major international rules, the AFSA rules, and in particular Article 15.2b, empowers the tribunal to conduct the proceedings in such a manner as it considers appropriate. That's at 15.1, and adopt procedures suitable for the conduct of arbitration in an expeditious and cost-effective manner. Article 17.6 provides that the tribunal may provide additional directions regarding the parties' written submissions or evidence. 18.3 also makes provision that the tribunal may hold any hearing at any convenient geographical place and shall organize the conduct of any hearing in advance in consultation with the parties or as it sees fit. Article 21.3 sets out that the tribunal shall have the fullest authority under the agreement to establish the conduct of a hearing, including its date, form, content, procedure, time limits, and geographical place. Important for these purposes is also Article 21.6. This sets out that the hearing may take place in person or by any other means that the tribunal considers appropriate, considering all relevant circumstances. And that also includes by way of video or telephone conference, or obviously a combination of the two. Just to note some observations here. So there's this express power to hold the hearing remotely by either telephone or video conference, supplemented by more general powers by the tribunal as to evidence and the conduct of proceedings more generally. The second real observation is that there are also wide-ranging powers which enable the tribunal to direct that a hearing be conducted remotely, even if not agreed to by the parties. And the third observation here is that we've seen an action where a tribunal was requested by one of the parties to attend physically in a single location. And in that instance, the tribunal actually refused and insisted on a purely remote hearing. So clearly there's this shift in thinking that we've seen. So what does this all really mean? Well, the overarching point here is that whilst specific powers and provisions do obviously help, there will generally be, as we've shown in the AFSA rules, wide-ranging case management provisions in the rules which enable the parties and the tribunal to conduct proceedings in a sustainable and climate-friendly way. Much of it comes down to case management powers of the tribunal and the willingness of the parties to the arbitration to act in that way. Some would also say that the converse also operates, in that there needs to be a willingness by the tribunal as well as general case management processes in place and encouraged between the parties. So how does this all come together, and how do we make green arbitrations work really, and how can we make it work for you? Within the framework of looking at these relevant rules, we're now just going to deal with some practicalities. The first point, and one of which Tom and I have labored today quite significantly, is to ensure that the parties and tribunal engage at an early stage on issues which address sustainable and climate-friendly practices. The opportune time to do so often already exists. You're already going to be having your case management meetings or your pre-arbitration meetings. At that pre-arbitration meeting, one should consider whether the hearing is to be conducted in person or remotely, or a hybrid of the two. Also consider how your own team will meet and gather, although of course that needs not be the subject of a direction from the tribunal, but it is something that you need to be talking about in and amongst yourselves. On this latter point, our experience is often that it's certainly in today's day and age and with the pandemic, is that that's usually accepted. Before you blink, you've got a Teams meeting invitation in your diaries. And giving thought to practical arrangements for remote hybrid hearings, you need to be thinking about what platform you want to be using, who will send out the invites, who is to attend, and that can all be dealt with by way of a protocol of sorts, which Pamela dealt with from a green arbitration perspective, and which I'll deal with in a little bit more detail shortly. As Tom mentioned, it's also important to address the issues of disclosure or discovery upfront and whether an e-data provider or service should be used. One should also consider whether it's possible to limit the ambit of disclosure and avoid the need for hard copies of the full discovered record completely. Similarly, what about your bundle? Can an e-bundle be used? If so, what are the rules for its preparation? Is there to be a hyperlinked index, as Tom mentioned earlier? Is an e-bundle provider going to be used? Is an e-bundle provider necessary? Is your bundle to be agreed right up front, early on, or is it going to be agreed between the parties later or down the line? You also then need to try and agree directions to this effect before the pre-arbitration meeting even takes place, or at least, or at the very least, arrive at your pre-arbitration meeting being prepared to have those kinds of discussions, or at least try and argue for them with that in the back of your mind. Not only will directions like these make your lives significantly easier in the long run and save last-minute internal discussions within your team or with your client about how you're going to be dealing with e-disclosure, but they'll also start to embed sustainable practices into the day-to-day conduct of your arbitrations. Now, the biggest challenge with a remote or hybrid hearing is how to prepare to ensure that it's smooth sailing on the day. I'm going to share with you some of our experiences as a firm, which highlight where things can go wrong and how to try and prevent them from happening in the first place. So firstly, key to an effective hearing, but particular of remote or hybrid hearings, is really early preparation. Preparation here is fundamental, really is key. For video hearings in particular, early hybrid hearing, including hybrid hearings, significant planning, testing and collaboration between the parties is necessary. And in practice, it often irons out issues early on rather than dealing with things on the day. Generally arranging a test call with the tribunal or the arbitrator and all other participants in the days preceding the hearing is what's really going to help. It's helpful if participants, and in particular your witnesses, do this test call from the setting that they'll be in for the hearing itself. And I'll get to witnesses in a little bit because that's practically that does deal with, there are some added complexities there. It'll also be necessary to agree to various aspects of how the hearing is going to proceed with other parties and the tribunal. And then you obviously set this out in the protocol for the hearing. For example, you need to think about things like who is to be visible and audible during the hearing. Generally, only those that are speaking with the arbitrator or your tribunal, the advocates and any witnesses or experts while actually giving evidence is what's acceptable. Thinking about things like how advocates can make interjections when the other person is speaking, where witnesses will be giving evidence from, how the oath or affirmation is going to be administered, or any undertakings that need to be provided, and need to be considered when looking at witnesses in particular. You'll also need to think about who will have access to the video link and who's going to be watching the hearing. We would also discuss aspects such as discussing how you're going to be communicating with your client and how you're going to be communicating with your legal team, including your counsel during the hearing. Tom mentioned a range of examples where often it's just easier, if at all possible, that at the very least your legal team is going to be sitting in one room together. There are, of course, a range of options for communication, and within the team, those include conference calls, emails, instant messaging, WhatsApp groups, if you like, or specialist electronic bundle software that includes private chat functionality. Obviously, where phones are used for such communications, all involved must be careful to mute their connection to any hearing so that sensitive discussions are, of course, not overheard by the other party or the tribunal, and also really to avoid any disruptions that might occur. Our recent practice and experience really is that the legal and witness teams, as I've said before, are generally located in one venue, which makes communication just so much easier. And you can also make provision for breakout rooms, and points can be discussed quickly whilst relevant. But that may not always be possible in circumstances. For example, if witnesses or other members of the team are in different parts of the world. Being a connected business, we see that a lot where different team members are sitting across the globe. And if you're dealing with hearings remotely in particular, you should always ensure that you have adequate computer equipment, a sufficiently strong and stable internet connection. And we know that in South Africa, that's not always a guarantee. But you really should try and consider whether there is a better alternative, or you could be in a better place. Do you have an inverter, for example? In our experience, though, what I will say is that in particular in recent times where we've had significant load shedding, we found that judges and arbitrator tribunals are generally quite understanding. Just yesterday, I had a hearing where one of our tribunal members, in fact, completely lost internet connection, and we made an alternative, and things kind of carried on with as little disruption as possible. It's also usually useful to have, if you have that luxury, to have more than one screen available, and the second screen or your second device can be used to display the electronic bundle. So you have the bundle on one screen, and then you have kind of the screen with the tribunal on the other, for example. That always is quite useful. And in general, unless you're acting as an advocate or giving evidence, just a little practical tip, your microphone should always be on mute, and if you're just observing, your camera should be off as well. Moving then just to witnesses, and I think witnesses, and considering witnesses and the impact that a hearing might have on having witness giving evidence remotely, it's important to note these points. For witnesses, it's obviously, of course, tempting to think that because you're not physically in the room with your arbitrator and with the counsel that are going to be cross-examining you, that it's somehow less formal, but that's certainly not the case. It's important to make sure that as a witness, that you have all of the relevant documents to hand for the hearing. If you're using an e-bundle, have a test session to make sure that your witness, or that you as the witness, are completely comfortable with and can access and navigate the bundle in its entirety. Considering, you need to consider your position and your background. Where are you actually seated? Have you got a big building behind you? Is the room clear? That kind of thing is also really important. Mobile phones and any other applications running on your devices must be muted. We've seen pop-up emails or uncomfortable pop-up emails pop up on screen, which really aren't particularly helpful. In arbitrations, in that setting, witnesses will also be required to swear an oath, and it depends on what forum you're in. It depends on if you'll be doing the oath or not. It will really be up to you and the arbitrator that's going to be deciding and administering that oath for you. You should, however, we would say, let the witness have the relevant wording for that oath or affirmation or undertaking in advance of the hearing, so that they can be familiar with what they're going to be asked to do right up front when they're giving evidence. It's also critical that the witness is not in communication with any other person, whether face-to-face or electronically. We've seen that witnesses may be required to, in fact, scan the room with their camera. So physically take their camera and scan the room so that they can show that no one else is present, that they don't have a phone with them, for example, that they don't have any notes. And that's also where your hearing bundle becomes really important. You're not allowed any notes, of course, or papers, whether in hard copy or electronic, in front of you when giving evidence, other than the unmarked copy of the hearing bundle, which is again why it's so important for you right up front to be familiar with the e-bundle, for example, that you may or may not be using. Consideration should be given to whether a witness familiarization session should be held to keep the witness or to help the witness acclimatize to the process, obviously without coaching, but often those kinds of sessions just practically give the witness a little bit more comfort with the technology that's being used. And then if the witness is going to be giving evidence in a language that is not the language of the proceedings, that obviously adds an additional level of complexity, but all of it, of course, is doable. We then obviously would encourage additional arrangements to be made to make sure that there's a translator, that the translation is clear and easily digestible, but also easily transcribable, and that just further testing just be done ahead of any translation services that need to be performed. And then finally, on the day of the hearing, it's obviously important to take the necessary steps to join the hearing early, in good time, before things commence, so that technical problems don't delay the start, which is why, with all of this, the overarching message is always going to be that preparation is key, and making sure that on the day, everything is dealt with adequately. I think that's it from me.
Thank you, Chloe. Some very useful tricks of the trade there, and hopefully many of those resonate with all of you and will help you to conduct remote hearings in a greener and leaner way going forward. Just before I open up the questions and check the Q&A box, bringing this all together, it's clear that the arbitration community internationally is moving in the direction of more sustainable business practices. Remote hearings, whether they're in hybrid or form or otherwise, have become the norm now and will likely stay that way. And technological innovations such as e-disclosure, e-bundling are increasingly commonplace and certainly in larger scale arbitrations. So we as an industry and arbitration professionals must prepare to think critically about what we do and why we do it. Can we do things differently? As we've attempted to show in this seminar, irrespective of whether you're a believer in climate change and in adopting sustainable practices, running arbitrations in a greener and leaner way actually aids the efficient and effective resolution of disputes. So I'd encourage you all to take a look at the campaign for greener arbitrations and the associated protocols, and to consider how you can make sustainable changes to the way in which your arbitrations are conducted. Thank you for your time. I'm now just going to stop sharing my screen and see whether we have any questions in the Q&A box. There's one which has come in, and Chloe, this is directed at you. Chloe, how would you deal with witnesses remotely if one of the parties is American and the counsel are US attorneys who coach their witnesses, unlike in South Africa and in England and Wales? So, so I guess dealing with a situation there, and commonly in international arbitration where you've got parties from different jurisdictions and perhaps different jurisdictions of different practices as to what's acceptable and what's not. How would you deal with that? Presumably dealing with or getting a protocol agreed up front is likely to be key, I would have thought.
Absolutely. I think that agreeing, and in particular focusing on that witness protocol is going to be fundamental. I think it's tricky because I don't think, and certainly in my experience, and funny enough, that's come up in South African arbitrations as well, where I've had some legitimate concern about witnesses being coached. It's tricky because your tribunal, you don't, in a South African context or in the context of the laws of England and Wales, you don't want to expressly state that that you don't want to have your witnesses coached. That to us is obvious. So it is a difficult situation, but I would strongly recommend that right up front you try and make things as clear as possible for your witnesses, and to make sure that things like ensuring that they are familiar with the bundle at the very least help. And then of course you're also able to control the fact that they're not going to be in the same room together, using a camera to scan the room to make sure that they don't have anything aiding them at the time, and that kind of thing. I would also maybe just encourage just to look at the governing law of your arbitration, because I think that would also largely steer you in the direction of who your tribunal is going to be, the identity of that tribunal, what that tribunal is going to be familiar with. For example, if your tribunal is, for example, based in the States and that's your governing law, well, of course, then coaching is going to be a little bit more acceptable than that of an arbitration in South Africa or in England and Wales, for example. I don't know if anyone else has got to add anything there, but yeah, that's how I would deal with it.
That's some comprehensive answer, Chloe, and I think you're spot on there, really. I mean, you have to look at what governing law is determinative of your agreement, and that's going to kind of indicate to you what kind of practices govern that arbitration and the extent to which coaching is or isn't acceptable. But I think, irrespective of that, getting that protocol agreed, knowing what the rules are, what the rules of engagement are, is also going to be important there. We've just had another question in, looking a little bit at the AFSA rules in particular, but I think adopting or picking up on this naysayer approach, which Pamela mentioned earlier. The question is that it sounds like the biggest challenge is getting past individual perceptions and attitudes, especially the "this is how we've done it for the last 40 years" attitude. Are the availability of infrastructure in South Africa's government potentially preventing that quicker adoption? We'll deal with that in two ways. Perhaps, Pamela, if I come to you first, and you kind of can perhaps talk us through how we can shift the attitude, change the mind of the naysayer, so to speak, and then perhaps I'll look at the South Africa perspective after that.
Yeah, sure. Well, it's a really fair question, and I completely accept that there are naysayers, and in fact, some of you on this call may be naysayers. I work with one. I work with one actually, and I'm not suggesting that I am going to overnight change attitudes and entire practices, but the way I sort of deal with naysayers is obviously firstly educate them in a non-patronizing way about the protocols and the campaigns movement, and it's actually quite compelling to see the number of signatories to the pledge. I think there's over 800 as of today. In fact, actually, no, that's wrong. The other day I was on a steering committee call where we'd had our 1,000th person sign the pledge. It's only been going for a few years. It's clearly a movement that is going to gather pace, and so you will be out of touch if in 5 years you're still doing things the original way. But just one thing at a time. That's my approach. Even if it's just showing someone how to use electronic comments on their laptop so that they've got the capacity. Showing someone that the keyboard shortcut Control F enables you to search a document. Some people don't know that, and those that do take it for granted, and it's part of our everyday routine. But if you start to understand the benefits of technology, it's just like, it's so old school to think that you would do it the paper way. So for me, I try to sort of get naysayers on board one thing at a time, and educate them. And the really challenging thing, I think, is when you've got a tribunal that's hard copy mentality, and but that's the hardest one to deal with. I'm dealing with it at the moment actually, and they're real long in the tooth, and they want in person and they want hard copies. And me and my opposing counsel were both, I checked the website, so you can see who signed the pledge on the campaign's website, and I checked and I saw that my other the counsel on the other side had both signed the pledge. And I when the tribunal asked us for a hearing bundle, I challenged them on that. And I asked them if it was necessary, especially in circumstances where this was a virtual hearing actually, because it was only at the time it was going to be virtual, it ended up being in person. But the tribunal insisted, and my counsel on the other side, they really rode back, and they said, we're going to do what the tribunal wants. And in that situation, it's very difficult to strike the balance, because on the one hand, I knew what I wanted to do, and actually all of us in Pinsent Masons were in agreement, this is bananas. But nonetheless, we exceeded, and the tribunal got their hard copy bundle. But I think that I wouldn't have felt so confident challenging them if I didn't have the pledge there. And I couldn't say, we've both committed to this sort of thing. And if, even if I didn't win that small battle, then, I've put it on the tribunal's radar that this is how we feel at Pinsent Masons. And so I do think that just talking about it, having these discussions, participating in the discussion and the movement is going to make change happen. Anyway, sorry, Tom, what about the local element of that question?
No, well, that's all very important, and I think that's a universal issue. Actually, we've all come across tribunals and other practitioners' council, even on your own team, who kind of have their ways of doing things, and I think that's probably the biggest cultural shift. But as you say, as people come to appreciate and understand the technology more, that will become less of an issue. I mean, if you look back 20 years, people were kind of playing Snake on their Nokia 3310s, but who's got the iPhones now, sort of thing. So it all goes in that direction eventually. And I think that kind of brings me on to kind of the question about South Africa's government in particular. And I mean, I did mention in that presentation that the deputy judge president in Gauteng at least has continued the status quo of remote hearings insofar as court hearings are concerned. Here there is clearly, I believe, an electronic submission platform for some documents, some court filings again, so it's moving in that direction. Although I think it's fair to say, I mean, and I think anyone who's tried to renew their driving license in South Africa will know that there are some bureaucratic idiosyncrasies which perhaps we need to get through a bit more quicker. But I think that's where organisations like AFSA, who are kind of more with the international curve, so to speak, can help promulgate those rules which encourage the use of technology for remote hearings to become the norm. And as I said earlier, and Chloe kind of pointed out as well, the AFSA rules do facilitate that approach. So yes, potentially that the regulation does prevent that, but I think as a community, that's where it's incumbent on us to kind of drive that change. And just finally, our last question, as things begin to open up, is the virtual trend being maintained, or are we falling back into the in-person hearing position? And perhaps here, I'll just go around the room. Chloe, maybe I'll start with you, just maybe in a minute or two, if you just summarize your recent experience.
Sure, certainly. I mean, I think it's a given that COVID definitely accelerated the thinking that we all had in relation to virtual hearings. They were, of course, not foreign before, but it certainly pushed us all to accelerate and progress how things worked before. So I think the point there is that as things do start to open up, I certainly have seen a continued encouragement to make things virtual, to continue to discourage printing of thousands and thousands and thousands of pages, to generally cut down the carbon footprint that an arbitration or an international arbitration has. And I will say in certain instances, there has been a little bit more, I wouldn't say reluctance, but there is more of a convenience factor for everyone to just kind of be in the same room. If you have the opportunity of being in the same room and if you're all in the same geographical location, and that goes to Pamela's point as well, is that if you have that luxury, then absolutely, you know, there are benefits to being in person. So there are those instances where if we've had the benefit, we would be in the same room. But certainly there is no stopping virtual hearings. I can't see the trend kind of taking a bit of a backseat. And certainly from a Pinsent Masons perspective, I think I speak for all of us that we certainly will be trying to maintain that virtual trend.
Pamela, does that kind of resonate with your experience in the Middle East as well?
I think so. In the Middle East, we are, you know, locally a bit sort of behind the curve. We like hard copies, especially the local institutions here. They do like their hard copies, but they are in transition now. And I think, you know, as I said before, that the signalling in the IBA rules and the ICC rules are quite important. That those very recent 2020 and 2021 changes, that they're quite important signals. And I also think that firms and institutions and things, that they've started to invest a bit of money now in virtual, and so it would be a bit sort of backwards to go backwards. But you know, we've invested it now. We've personally at Pinsent Masons, you know, we've got business operations colleagues who are not lawyers and who are there to enable us to do things more effectively. That, you know, we have software engineers at Pinsent Masons, we've got e-data managers and things, and that's investment that we've made because we see this as something that is, you know, this is the future. It's not going to go backwards. So COVID was certainly a catalyst, but it was a movement that I think was happening anyway. And so yeah, no, I don't think it is going to go backwards, I'm pleased to say.
Yeah, and just to round that off, you know, I'd agree with that wholeheartedly. I mean, certainly in terms of the hearings that I've held so far this year, after the lockdown regulations have started to open up a bit, you're finding even now that that the preference is for remote hearings. I mean, I mentioned in the session a little bit earlier that in one of our arbitrations, the arbitrators actually insisted on a remote hearing against the wishes of one of the parties who wanted an in-person attendance. So I very much agree with what you've said, Chloe, Pamela, that no, the trend is here to stay. I think there'll be ways in which that's developed as the technology improves and as processes improve. But I think the concept is very much here to stay, and that's what the Green Arbitration Pledge and protocols are all about, of course, to make sure it stays that way. Okay, well, I'll draw an end to the Q&A there. Michael, should I hand back to you for some concluding remarks?
Thank you. Yes. The only concluding remark apart from thanking you all for a fascinating discussion, is that speaking for myself, I'm sure speaking for such colleagues as I still have of the same age and stage, thinking back over 50 years of practice, the changes that have come about in the last 2 years make all the cumulative changes of the 50 years before that completely trivial. It's an astonishing cultural change that has come about, clearly, of course, triggered by COVID, but the degree to which the advantages of the new culture has been identified and has been encouraged by innovative thinking in the arbitration world is, I think, wonderfully impressive. I think it holds out a great dividend in terms of cost, time, and convenience for all the participants in arbitration. And it's just wonderful to hear from a generation which regards this as both attractive and easy, which is very different from my view of it all. Thank you so much. And can I remind all our listeners that the webinar has been recorded. It will be available for future reference on the AFSA website, and I do invite you all to take advantage of that opportunity to rehear and to think about the issues that have been raised. Thank you so much, and thanks every member of our panel for a lovely discussion. Thank you again.
Thank you very much indeed. Thank you.
Thank you, Michael, and thanks to AFSA. Thanks, everybody.
Thank you all.